So there's no basis now for Bragg to stretch that out to include and mean a bunch of other stuff. And this is fun. Bragg whiffs. Oh, but they cannot rebut presumptive immunity. It was invasive testimony about his daily activities. Claiming that the testimony is not going to influence any future president is not enough. No, unlikely is not the standard. You have to show it's no dangers. Similar to Madeleine Westerhout, Bragg misstates their burden by saying it's unlikely to impact presidential decision-making. That's not what the Supreme Court said, unlikely. It's not the rule, Bragg. President Trump submitted his final reply on the presidential immunity issue. Here's what it looks like. We know this is the case involving Alvin Bragg's prosecution, 34 felony guilty verdicts from New York. Judge Juan Merchan presiding over this thing, even though his daughter works for Kamala Harris now. But here is Trump's final reply. And so remember, the way this goes is Trump submitted motion saying that the verdicts need to go bye-bye. They need to be dismissed because presidential immunity applies. And they lodged their objections many times before the trial even started. And then when the trial started, they lodged it again. They said, Judge, you have to stop this now so that we can determine whether there is immunity. There's a pending case at the Supreme Court. Just pause this so that they can sort it out. Then we'll come back and deal with it. The judge said, no, I'm not going to do that at all. We'll just have a trial because they needed the conviction for the election. Well, the judge screwed that up. The court came back down, said immunity does apply. So Trump said, time to dismiss the case. Bragg responded. Now Trump submitting a reply, and we'll see where this goes, but let's unpack what's inside. All right, Judge Juan Merchan. The Supreme Court of the United States ruled conclusively and unequivocally that President Trump is protected by immunity for his official acts, period. Now, in this case, a politically motivated Bragg violated that immunity, and he did it by using official acts evidence in grand jury proceedings before this even ever started and at trial, which we covered here extensively. And so therefore, because he did that, this case must be dismissed and the jury's verdicts must be vacated. Now listen here, Judge. President Trump respectfully submits this reply in further support of his motion on immunity and in response to Bragg. Now Bragg, when he submitted his response, Bragg concedes that the Trump Supreme Court decision from the Supreme Court was an intervening decision. So it came back down and intervened in the middle of a case. Like, this case is not over because sentencing hasn't happened. And so it's coming back. Like, it's still ongoing. It's still pending. It's not like, hey, game's over. You can't change the score. Sorry. And that resulted in a newly announced rule. Okay, so Bragg is like, oh, crap. Like, all right, yeah, like, okay, this came back down. Now, the team says, because that is true, and because President Trump raised presidential immunity objections with this court and the Court of Appeals before this even started, Bragg's preservation arguments are meritless. And in Bragg's reply, he said Trump didn't object. And you have to object in order to preserve that issue on appeal. Now, Bragg fought President Trump's pretrial motions, which were in writing, so we submitted it in writing, immunity. And Bragg urged the court to rush ahead to trial anyways. And you did that, Judge. And that was wrong. The Supreme Court in the Trump case made clear that pretrial review before the trial starts was necessary. You have to have some sort of an evidentiary hearing to decide, is this immune? Is there a presumption of immunity, or is this unofficial and there is no immunity? Where does it fall? Now, President Trump is entitled to absolute immunity and to disputes that a rebuttable presumption of presidential immunity can ever be sufficient to protect the interests at stake, which is an issue the Supreme Court expressly left open. But in light of this resistance to the reasonable pretrial request to wait for the Trump decision, Bragg is not entitled to a post-trial rebuttable opportunity. The bell cannot be unrung now, so we can't fix this after the fact. Bragg's presidential immunity violations were not merely trial errors. The violations were not harmless like they're claiming. Their star witness committed perjury before and during the trial. And so in any event, harmless error review is an inadequate safeguard for these structural violations of the Constitution, which adversely impacted the mode of the proceedings mandated by the Trump court on the immunity decision and the constitutional structure that will guide the future presidents. And so the Supreme Court came down and they gave us a framework. We said that our propositions to the court were to wait till they gave us a framework so that we could come back, apply that framework, say, okay, they want us to go this way, so we do that. Then we could settle that. Then the trial can move forward if you found that there was, in fact, conduct here that could be charged. But you don't get to do that after the trial. It has to happen before, is what they're saying. And so that's the opening statement, but they get us some more details here. They tell us, there is no procedural bar to dismissal. Part of what Bragg was saying is that Trump was out of time. He raised his arguments too late. The verdict has already been rendered, right? Time's up, clock clock has already expired to 0. They say President Trump's dismissal motion was not waived. We didn't forfeit it at all. In the Supreme Court case, the Supreme Court addressed first impression questions of lasting significance, and they issued a newly announced rule. Now, thus, Trump, the Supreme Court case, constitutes good cause for the timing of the motion. Okay, so in other words, Trump didn't delay this. Trump wasn't waiting around and maybe we should file it and not. As soon as the Supreme Court came down, boom, they turned around, filed. Oh, perfect, new rule. We can file that. And so remedying this is in the interest of justice. So it's a pervasive presidential immunity violation. We already objected. We already told you to wait. You said no. New rule came down. We say it applies. And it does. They say the split decision in the case that Bragg cited doesn't support their arguments. Why? Because that concerned a distinct issue, which is about appellate preservation and was not about good cause or interest of justice. Not like that at all. Here, President Trump has presented the argument to this court. There's a clear and adequate record already. And in that other case, it relied on other things that are not raised here. None of that applies here. So they say this is why dismissal is required. It's in the interest of justice. The essence of immunity is that a possessor's entitlement doesn't have to answer for his conduct in court. That means everything. It doesn't mean you're only immune from a conviction, like you can go to trial, you have to show up to court multiple times, you have to sit there where you have, Bragg or Tish James, harassing all your people. You just have immunity. You don't have to suffer all of that from the outset. Now, the Supreme Court rejected the claim that grand juries will not permit political or baseless prosecutions from advancing in the first place. This is a sentence the government always comes back and says, well, that's why we have checks and balances in the system. What checks and balances? Well, we have honest prosecutors. Yeah, right. Okay. What else do you have? No one believes that. Presidential immunity is necessary where a prosecutor is trying to charge the president for his official actions. In other words, the Constitution says the president can do this, so you cannot be charged with a crime for that. Bragg violated the presidential immunity doctrine by presenting official acts that he's allowed specifically to do by the Constitution, evidence to the grand jury. Therefore, the indictment must be dismissed. Is Trump allowed to have a conversation with his White House comms director? Of course. Should that be protected as official acts when you're governing the White House? Bragg offers no independent arguments, of course not, about the official acts evidence that they presented to the grand jury through this person. He offers no independent arguments about any of this. Through this person and through this person. So these are probably like two official people, right? This is an official person here and an official person here. Can you get any evidence that they brought in independently from someone else who's not official? No. And so for those reasons, that evidence violated the immunity doctrine. These are official people. Bragg's mischaracterizations of arguments about this person or thing as vague and cursory are not a basis for ignoring other additional violations of Trump's immunity. He has immunity from official acts, SCOTUS said that, including from testimony of one another from his closest White House advisors. And so Trump's motion cited to this and that challenged testimony, which included conversations that Blank had with President Trump during his first term in office regarding these issues. And similar to White House conversations with Hope Hicks, who was White House comms, President Trump's statements to Blank were part of discussions in which he was seeking advice from Blank, official, regarding Blank, presidential stuff. And so likely due to the fact that the president's need for complete candor and objectivity from advisors calls from great deference from the court, what the Supreme Court said, Bragg does not even try to rebut any presumption of immunity for official acts that were presented to the grand jury. Doesn't even try to raise it. Now, sufficiency and harmless error analysis do not apply to Trump's immunity violations. The requirement that prejudice may result from these violations is satisfied, as the Supreme Court explained previously, because this is likely to create a prospect of an executive branch that cannibalizes itself. And so in addition to the harm to President Trump, any failure by the courts to faithfully apply the presidential immunity doctrine will irreparably damage the presidency. These violations harm the welfare of the community. They weaken the presidency. It's very serious, and so accordingly, the indictment must be dismissed. SCOTUS gave us a good basis for this. Now, the jury's verdicts also cannot adequately stand, and Trump has made his objections adequately preserved. Bragg does not dispute that they did lodge trial objections to official acts testimony. He knows we said it when they called Hope Hicks to testify and when they tried to get these forms admitted. But they wrongly contend that President Trump's other challenges are largely unpreserved. Wrong. Trump raised presidential immunity objections to the trial proof before and during the trial, including in the Court of Appeals. In fact, Trump says we raised it many times. In March, a pretrial motion sought official preclusion of all the official acts. So to keep them out before the trial even starts. They said, oh, Hope Hicks is going to come testify. Michael Cohen's going to come testify. And so it should apply to everybody. Now, after the court, Judge Mercan erroneously denied the motion based on some law he snagged out of his booty, President Trump sought a writ of prohibition in the First Department, tried to take this up on appeal. In that petition, Trump reiterated objections to this person, this person, this person, and this person doing these things. And the court was fully aware of President Trump's arguments in that proceeding as counsel for Your Honor entered an appearance and opposed the application. Wow. So a judge got a lawyer? Now, after the First Department, the Court of Appeals, denied the petition in a manner that's inconsistent with even its own case law, in this case called People versus Orstein, as well as the Trump Supreme Court case, they said, okay, we have immunity. Merchan said you don't. They took it up to the Court of Appeals. Hey, we have immunity. Can you tell him we do? They said, no, you don't. I said, okay. So they were in violation of their own rules, their own case law. Then Trump came back down and renewed presidential immunity objections again during jury selection. Also sent another pre-motion letter. On April 19th, the court acknowledged that the parties had already made your arguments. Judge said, stop talking to me about it. You've already made your arguments. Trump also objected the first time that the presidential immunity issue arose during trial, when Hope Hicks testified. The court overruled. Objection overruled. He said, I believe I ruled on this. And he said, hey, defense idiots, you do not need to object as to each question. Okay, I got it. Stop objecting. Now, in order to make clear that President Trump did maintain the immunity objection as to documentary official acts, the defense objected to the form. Then Bragg incorporated by reference their since rejected arguments about immunity. The court issued a two-word ruling saying, I agree. And for the avoidance of doubt, the defense renewed the objection to the Twitter post, object again, and they said no. Now, for purposes of this, nothing more was required. So here, the Court of Appeals found an issue to be preserved because there was a general motion to dismiss. Okay, like, in other words, that's enough. What we did was plenty. On multiple occasions, they say the court was plainly aware of and expressly decided that presidential immunity did not exist. And so as a general matter, okay, in order to preserve a point, a lawyer is not required to repeat an argument that the court has definitively rejected. President Trump was not required to antagonize the court or to test your patience by saying objection, objection, objection every 2 seconds. Now, Bragg, once again, relies on another case that is distinguishable here, doesn't apply. And presidential immunity errors are mode of proceeding defects for which preservation is not required anyways. For all these reasons, Bragg has not established any procedural bar as to why we can't review their violations. Now, continuing, they say Alvin Bragg also did not open the door to these immunity violations, saying Alvin Bragg in his reply and his response wrongfully claims that President Trump opened the door. So Trump can't say you got to keep this out because he wanted it in the form of 3 2018 tweets and testimony from Cohen about a congressional investigation. They say, come on, Bragg. The argument fails because Trump's strategic decisions about Cohen's lack of credibility were informed by the dismissive treatment from the immunity decisions. The only reason that we talked about any of that is because we had to, because you overruled us on immunity. If we would have had immunity, we wouldn't have gone there. Moreover, the only authority they cite is New York evidence rule. It's a relevant case law. The opening the door principle was limited in the Supreme Court case here, and so it just doesn't apply. Now, also, they're talking about removal proceedings. Have no bearing on this case at all. There's no authority for Bragg to say that Trump waives his defenses because he didn't raise them in a removal proceeding to federal court. Doesn't matter. Didn't have to raise them there. Saying the court's reasoning is irrelevant. And so nothing in that removal proceeding can be used to rebut any presumptive presidential immunity that Trump has, thanks SCOTUS. Now they continue in subsection D, saying, Your Honor, there is no public record exception to presidential immunity. Bragg says, well, maybe there's some immunity, but kind of there's an exception to it. Says no, there's a footnote in the Trump decision where they're arguing that presidential immunity does not apply to evidence that consists of a public record of an official act. So this is a made-up exception, they say. It's refuted by the Trump opinion and common sense. There's a public record exception? What? Bragg elsewhere recognized that there are public comments that the Supreme Court indicated would qualify as official presidential conduct. Yes, because the president has to speak to the public. Bragg claims that they did not violate the presidential immunity doctrine by offering Trump's tweets because they admitted nothing more than a public record, right? It's not an official act of anything. It's just a public record. Well, if that were the case, then the Supreme Court wouldn't have wasted an entire subsection analyzing public statements, including tweets. They wouldn't have talked about the bully pulpit. They wouldn't have talked about the president's extraordinary power to speak to his fellow citizens. And so they're just seizing on this footnote. And in that portion of the opinion, the Supreme Court was talking about bribery prosecutions from Amy Coney Barrett. Bribery is a unique constitutional thing. There's a narrow meaning to that term for official acts. It's codified in the U.S. Code. At most, footnote 3 of the Trump decision stands for the proposition that federal prosecutors could, quote, point to the public record in bribery prosecution. So there's no basis now for Bragg to stretch that out to include and mean a bunch of other stuff. And this is fun. Bragg whiffs. Oh, you can just picture Bragg just coming out there trying to hit a piñata or something, just whiffing, probably doing a full, I don't know, 720 and falling over. Oh, man, I can see it here. Prize happened. Hope he's okay. Says he whiffs at a straw man in response to President Trump's reliance on Clinton, which confirms that the public statements on behalf of a sitting president are within the outer perimeter of presidential authority, even when they're about private parties in private matters. In the Clinton case, there was stuff about defamation, and they say the Supreme Court said that a state law defamation claim arguably may involve conduct within the outer perimeter of the president's official responsibilities. Yeah, look at that. So maybe this will even apply to the E. Jean Carroll case. I think it will. In Clinton, in other words, Trump's defense already has the citation. Okay, they already have the case cite. Supreme Court said arguably may involve outer perimeter for official responsibilities. That defamation claim was based on responses by Clinton to Paula Jones, issued by White House aides. The fact that 8 justices who joined the Clinton opinion believe the public statements by White House personnel in a private party responding to Jones were arguably within the outer perimeter. Oh boy. E. Jean Carroll, Roberta Kaplan, George Conway having a bad day today. They're going, oh, I forgot about Bill Clinton. That President Trump's tweets and conversations with advisors regarding allegations of pre-presidency matters are not manifestly or palpably beyond presidential authority, right? The president has to respond to those types of attacks, which are in the outer perimeter under Trump. So even if the language from Clinton could be considered dicta, which we don't concede, dicta from the Supreme Court is not something to be lightly cast aside. So therefore, Clinton provides powerful support for President Trump's arguments that Bragg's proof in the grand jury and at trial involved official acts. It's great. So here is the bad evidence that they admitted in Bragg's case. First, Trump's official communications with Hope Hicks. Bragg elicited testimony from Hope Hicks regarding official acts by President Trump, all protected, all immune. Specifically, Hope Hicks testified about her conversations with President Trump while she was the White House comms director, specifically about a Wall Street Journal article, a New York Times article, a CNN interview, which just like Clinton responding to Paula Jones, outer perimeter, inside. President Trump's conversations, then existing statements and allegations levied during the presidency by Cohen, Daniels, and the FEC, all presidential stuff. Bragg cannot escape the presidential immunity doctrine by claiming that the subject matter of those discussions occurred prior to Trump's first term. He's saying, yeah, but they're saying that you did these things in 2016 or 2015. Okay, but they're talking about it as he's the president. That brings them inside the envelope. Otherwise, the president could just be attacked with everything else that came up before and couldn't respond. It would be ridiculous, right? Obviously, the president is going to come under additional heightened scrutiny and attack. So as with blank redacted, President Trump spoke about these topics with Hicks, a close advisor, pursuant to his core constitutional powers. He did so as part of his efforts to supervise Hicks and her work and to ensure that Hicks and her staff were prepared to address questions that were being communicated by the White House about Trump. The absolute immunity that attaches to these conversations is not based entirely on a government official's role. Rather, the immunity derives from the nature of the authority that President Trump was exercising. He has that power. Now, in this regard, Bragg did not address Trump's citations to the executive vesting clause in the Constitution, or to the take care clause, or to the Myers case, or to the SELA law that was referenced in the Trump Supreme Court case. These provisions establish that a president does have the power to use the bully pulpit to persuade Americans, including by speaking forcefully or critically in ways that the president thinks would be in the public's interest. The president can exercise this constitutional authority. And so because it is preclusive and exclusive and conclusive, Congress cannot limit a president's ability to speak to the public. Therefore, absolute immunity applies. And Bragg's suggestion that a president's internal communications advisor, that they're palpably or manifestly outside the presidential authority is brazenly inaccurate. Their argument proceeds by ignoring Hicks's trial description of her job responsibilities. She said that she does everything. She coordinates all of the communication efforts for the administration, and that her job is to showcase the president in a good light. When compared to that testimony, Bragg's citation to another case is frivolous. Each of those scenarios in those other cases are ridiculous. They're like party fundraising events. That's not what this was. Trump did not speak to Hicks about these topics in 2018 as a candidate. He spoke to her as the president. Now, although it's true that the demands on a president's time may include some private matters, it's true, the testimony here that's based largely on media inquiries were all routed to Hicks through the White House. As part of this response and coverage on CNN, Trump spoke spoke with Hicks so that she could be prepared. They were part of his official responsibilities, well within the outer perimeter, and Bragg's efforts to say these are private conversations is no support, even on the record. The facts that were presented at trial show it. So Bragg has not met any burden to rebut the presumption of immunity. If the presumption of immunity exists, it applies despite a hostile prosecutor's conclusory assertion that official acts would not impact the president's official decision-making. To rebut the presumption, Bragg needs to establish evidence that would pose no dangers, right? That's not how this works. It's no dangers to the authority or functions of the executives. That's what the Supreme Court said. So with respect to the official internal interactions between the White House and the president, Hope Hicks, as well as Madeleine Westerhout, as well as this person who never came up at trial, the Supreme Court has recognized we have to protect these communications. And so Bragg cannot rebut the presumptive immunity that goes over to Hope Hicks. Madeleine Westerhout also was brought in. Bragg acknowledges, they have to, that the challenged portions of Westerhout's testimony concerned Trump's basic work habits, his work practices as president. Oh, bummer. As well as national security procedures. Remember her testimony? They brought her in and she was talking about how Trump would call Melania when he was going to be late, talking about the Situation Room, methods of air transportation, all using official White House stuff. Now, there's no de minimis exception to trigger presidential immunity, and Bragg does not address Trump's argument that the immunity at issue is absolute because President Trump's activities were pursuant to his core responsibilities as the commander-in-chief. Bragg finds it, quote, difficult to imagine criminal liability stemming from general work practices, but that's exactly the type of evidence that Jack Smith got. Apart from that feigned lack of imagination, Bragg does not seriously dispute that Trump's decisions about how to run a White House were at least within the outer perimeter. It's like you're asking about his job, like specifically. So Bragg, as a rebuttal, offers irrelevant assertions. He was talking about the purpose of the testimony. It's not about what she said he was doing specifically. It's about the purpose. And it's about what mattered to prosecutor was this. But they cannot rebut presumptive immunity. It was invasive testimony about his daily activities. Claiming that the testimony is not going to influence any future president is not enough. No, unlikely is not the standard. You have to show it's no dangers. Yeah, they can't do that because any future testimony at a post-presidency criminal trial about the management style of the Oval Office would render him unduly cautious, right? If you're allowed to go in there and just, well, tell me about how you run your Oval Office. What? Some hack prosecutor can do that? It would be an intrusion onto the presidency, and the Supreme Court says you can't do that because the country elected that person. So we give him protections against hack prosecutors like Bragg and Colangelo. Now, they also brought in Trump's Twitter statements, saying that Bragg relied on evidence of 5 official tweets that Trump issued as part of his presidential communication. Even if the court extends the Trump Supreme Court decision to recognize presumptive immunity for outer perimeter official acts, Bragg has not rebutted the presumption described by the Supreme Court. In fact, contrary to Bragg, there is no requirement that a president's public statement purport to discharge some official duty in order for it to be an official act. Like, only if you say, I hereby declare as president that the following is true. Like, okay, that's official because you said that? No. Public statements certainly can qualify as official, even when not obviously connected to a particular constitutional or statutory provision. In any event, 2 of the tweets reference ongoing investigations and therefore did relate to the president's core official duties. These tweets touched on the investigative and the prosecutorial decision-making, which is the province of the president. And so therefore, Trump is entitled to absolute, unrebuttable immunity with respect to at least these 2 tweets. And context also matters. Remember, the Supreme Court said that in the Trump case. They say that for each of the challenged tweets, President Trump used an official communications channel of the White House. There were White House employees involved, Madeleine Westerhout, Dan Scavino, shout out to both of them, to address matters of public concern on the X account. Thus, President Trump's position is supported by other case law, which says that an official who uses government staff to make a post will be hard-pressed to deny that he was conducting government business. Now, the fact that the tweets also reference Cohen and Daniels did not render them unofficial. Most of the president's public communications, most they say, are likely to fall comfortably within the outer perimeter of his official responsibilities, especially where the presidential communications address current matters of public concern. Daniels, Stormy, described in a 2018 tweet by Trump, he was responding to false public claims by Daniels and others. This other exhibit was about a widely covered FBI search targeting Cohen, another matter being publicly investigated at the time, which Trump oversaw. This was about Trump's guilty plea, similar to the media activities where Trump discussed with Hicks, even if underlying historical allegations were private and pre-presidential, these public tweets concern developments when Trump was president. Nothing in the Supreme Court says that that it's limited to pressing policy or public emergency. None of it. And a prosecutor's ex post determination after the fact that a national voice was not needed at the time is not enough. The tweets were arguably at least within the outer perimeter and not palpably outside the outer perimeter as defined by the Supreme Court. So, although immunity attaching to these tweets is absolute, any efforts to rebut the presumption of immunity is deeply flawed. The presumption would apply because Trump issued the tweets pursuant to his official authority to do that. It's therefore legally inaccurate and a non sequitur to claim, as Bragg does, that the tweets bore no relationship to any official duty of the presidency. No. The dangers of intrusion on the presidency are apparent here from Bragg's own words, that future presidents will be concerned that their public statements may be used as evidence in criminal proceedings. And those future presidents could take no solace in the fact that Bragg casually reduced Trump's statements to personal opinions. No, that's his opinion. Their argument boils down to a claim about tweets being motivated by a private purpose. And you can't talk about motivation. Supreme Court said so. So Bragg's entire logical underpinning is invalid. Thus, even if the presidential immunity relating to the tweets could be deemed presumptive, Bragg has failed to carry his rebuttable burden. So Trump is immune there. And also, Trump responded to the FEC inquiries. They used that as evidence in the trial. Trump is protected, they say. Trump, in fact, used his exclusive authority under the Take Care Clause to address the decision-making at the FEC. Bragg blatantly ignores the Supreme Court decision, arguing 3 separate times, in fact, that Trump's actions in connection with the FEC were not official because in their view, Trump intended, motivations, to interfere with the investigations. First of all, they falsely characterized Trump's motive, and by the way, intentions are irrelevant. The text messages involving Cohen and Jay Sekulow reflected decisions by Trump in response to FEC inquiries. He was the president. Those were in the outer bounds of the presidential authority, and you can even go back to the Clinton dicta if you want. In addition, Bragg plainly wanted the jury to infer that Trump spoke to the AG about the FEC. The inference pursued related to an absolutely immune official act, and so Trump is protected. No part of the Supreme Court decision places a burden on Trump to acknowledge whether he actually ever did that. The mere suggestion of such a defense burden is further evidence of their reckless and untenable approach to this case. Whether or not the conversation happened doesn't matter. It violated the immunity because it concerned a conversation Trump is protected under. And to the extent that the court applies presumptive immunity here, Bragg doesn't even make any effort to rebut it. Similar to Madeleine Westerhout, Bragg misstates their burden by saying it's unlikely to impact presidential decision-making. That's not what the Supreme Court said, unlikely. It's not the rule, Bragg. Compounding that error, Bragg again invokes impermissible arguments regarding motive and intent. Not allowed to do that. Said Trump was just being gratuitous. The prospect of prosecutors seeking to imprison a former president by using his own exercise of discretion would impermissibly intrude upon his discretion. They can't go into his brain and decide what his motives are. And presidents, if they were allowed to do that, would have valid concerns. Now, they also brought in other evidence. Michael Cohen testified about Trump's public message in response to congressional investigations, saying there was no Russia, Russia, Russia. Bragg did not even address the explicit recognition of presidential authority to engage with Congress, nor is the presidential immunity violation excused by Bragg's argument that Cohen brought this up only because he was trying to justify his own reasons for lying to Congress. In other words, there's a proper reason to bring this in. It's because Cohen's a liar. Yeah, that's really wild from a prosecutor. In addition, through Cohen's reference to pre-pardons, Bragg sought a highly prejudicial and inaccurate inference relating to the alleged use of a constitutional pardon. None of that should have been allowed in either. And similarly, this form, OGE form, saying it rests entirely on this public records exception, and none of this was harmless. Self-serving explication of the trial record can't save Bragg from the fact that their entire case turned on Michael Cohen's credibility, which was severely lacking. Bragg concedes that the official act's evidence was presented to bolster Cohen's weakness. That's why they emphasized it. Supreme Court warned about this, saying it raises a unique risk that jurors' deliberations will be prejudiced by the views of the president. And so jury selection demonstrated that was a risk in this case. It cannot be said that these errors were harmless. They were catastrophic. More fundamentally, harmless error analysis is not even available to Bragg. These are immunity violations. These are structural errors. This is a New York mode of proceedings problem. Prosecutors could violate this doctrine, and so harmless error review would eviscerate the immunity. Just, it's not that big of a deal. It's just harmless immunity. We would have gotten any other way. We say these are structural errors because we are protecting the institution of the presidency. Separation of powers. Bragg cannot say this doesn't matter. Immunity errors are too hard to measure. And so these violations were mode violations. And so So in conclusion, the court, Mercan, should dismiss this indictment and vacate the jury's verdicts, all 34 guilty findings on violations of the Presidential Immunity Act and the Supremacy Clause, signed by Todd Blanche and Emile Beauvais for Trump's defense, submitted to Judge Mercan in the New York Alvin Bragg prosecution, state of New York, and submitted by the defense. So we'll see what the judge has for us in response. This was the affirmation of Todd Blanche, and this has landed on Mercan's desk. And so we'll see when we get a ruling from him. Of course, we're not expecting anything anytime soon. We know he's giving us until at least September to decide where he's going to go on this. So we'll continue to cover it, my friends. Thank you for subscribing as we do, and we'll look forward to seeing you back here on the next one.